Okay, secondly, let's move to the matter of the operation of the community center and the contract that's been in existence with Asphalt Green since sometime in 2009. As the members are aware, the public is aware, the press is aware, this has been a difficult process, to say the least. When I arrived in July, what I found was that the previous administration had reviewed that contract when they came here to the authority, because the contract preceded the previous administration in its negotiation and execution. So it was a deal that was made during a period in 2008, 2009, was executed in 2009, and Dimitri's predecessor and my predecessor arrived after that contract had been executed. They found the contract to be unworkable in a number of material respects, and as a result of that entered into discussions with Asphalt Green, the prospective operator of the community center, to try to amend that contract to make it more suitable. When I arrived, those negotiations had been underway for some extended period of time, and frankly had not yielded a positive result. And the authority was at somewhat of an impasse with Asphalt Green as to what that outcome would be, and a casualty of those discussions was continued delays in the opening of the community center and access to that facility by members of the community. And I was mindful of the fact that it was important to expedite the process and come to a conclusion, but that the conclusion had to be appropriate in the circumstances. And there were two fundamental problems, if I may oversimplify. One was that the nature of the contract put the authority in a position where a private enterprise, understanding it's a nonprofit organization, but it is private enterprise, is spending public dollars, taxpayer money, without adequate transparency, without adequate supervision. It was inconsistent, the functional aspects of the contract were inconsistent with our obligations for transparency, for oversight, and for appropriateness in the expenditure of taxpayer dollars. This was not the result, and I spent some time getting to know Asphalt Green, understanding the history. How did we get here? I must tell you that I found no suggestion of any untoward activities, no chicanery, nothing along those lines whatsoever. After my review, I concluded that Asphalt Green is a stellar operator of their community center on the Upper East Side. They do an outstanding job. They deliver services to the community. They do it at a reasonable cost. They run a great facility. They are very highly thought of. So the effort on the part of the authority that precedes our involvement, and which is one in which this authority recruited Asphalt Green to this relationship. They didn't come to us. They did not respond to the initial RFP that was put out there. Others did. The authority, in its judgment, deemed those responses inadequate to our needs and recruited Asphalt Green to respond to a revised RFP. From that grew the contract. I think the contract was negotiated in good faith. I think everybody was honest about it, but I got to confess to you, I think they were a little smarter than we were. And they got a deal that was quite favorable. That deal contemplated the requirement for this authority to subsidize all operating expenses of Asphalt Green, irrespective of the amount. Now, they would submit a budget, and we could talk about the budget, but at the end of the day, what the contract said was, whatever we spend, you have to pay. And I've already commented on the nature of those expenditures perhaps being inconsistent with what taxpayer dollars should be spent on. Not that they're bad things, but there's a difference between spending private dollars and you report to a board, you get your funding from services you provide, you get your funding from donors, wherever you get it, and you report to those narrow constituencies as opposed to the requirements of what goes on with taxpayer dollars. So we had an unending, no cap commitment to subsidize any and all operating losses of the community center. If the community center made money, there would be a division of those profits, 60% to the authority, 40% to the operator. That didn't make any financial sense to me. And it didn't make any financial sense to the members of this board, as you might imagine. And it did not make any sense to the staff that was then in charge of the authority. And they made their views known vigorously. The other issues primarily involved community access to the facilities and to the exterior spaces. And how would that be handled in a way that was fair and equitable, but still allow the community center to function. Alternatives were considered, including the possibility of simply defaulting on the contract, issuing a new RFP, and bringing in a private commercial operator to run a health club. Impractical. The center is designed to be what it is. It is not designed to be a commercial health club. Millions of more dollars would have to have been spent. In any case, if we did not find an acceptable way to amend this contract, our best estimate was, if all went well, we might open that center in the early part of 2014. So additional delays, and I think you all would concur that we spent this money, got all this equipment in there, and it's all there, it's sitting idle. If you let it sit long enough, it will not work when you go to turn it on. It's just a cardinal principle. The asset will deteriorate if it is not being used and maintained. And that's an unknown exposure. So what we faced was what seemed to be an irreconcilable conflict between a contract that had functional aspects that were inconsistent with protocols we need to observe, and financial arrangements that were unreasonable from our perspective, against a legitimate operator who can do a good job, who negotiated a contract in good faith and felt they were entitled to performance under that contract. Counsel advised us, and we've had many executive sessions about what the lawyers had to say, that if we defaulted under the contract, we would lose in the court. We would spend millions of dollars in legal fees, and we would end up with an imposed judgment against this authority somewhere between $3.5 and $13 million when the dust finally cleared several years from now. And the center wouldn't open for another 15 to 18 months, given the protocols we would have to go through. So that's the hand we were dealt. What we have done is reached an understanding with Asphalt Green, subject to the affirmative vote of this board, in which the authority will not take any financial risk to the operation of this center. There was embedded in the contract a requirement for the authority to provide all utilities at our expense, as use might drive up cost, as rates might drive up cost. We get the bill, we pay it. We found that unreasonable. We have imposed a number for those utilities. It is approximately 60% of our own internal estimates of what that cost might have been. That's a known number. It is capped. It doesn't change throughout the term of the lease. There was embedded in the original contract a requirement for what we call stay-in-business capital expenditures. So that is essentially maintaining the asset in repair and replacement. And that budget was about $225,000 a year. It was ongoing throughout the 10-year lease. We have capped that at the end of 3 years to go away. And we have introduced the concept of percentage rent to this lease beginning in year 6, whereby Asphalt Green has provided us with estimates of its revenue. And we have arranged a graduated scale of revenue sharing to the authority. So understand clearly the concept. We have nothing to do with their expenses. We have no oversight to what they spend, why they spend it, or how they spend it. It's none of our business. It's not public money. They get their revenue stream, they have to run their operation. If they lose money, they're at risk for losing. If they make money, it's wonderful. Beginning in year 6, we receive a portion of their revenue, not of their profit. If they don't hit their projections, and in consequence, the revenue stream we're not going to receive, that we are going to receive, is less than 90% of what is anticipated, they have to write a check to make it up. If they cannot, or do not write their check, their lease will be terminated. So the risk of the authority has been eliminated. We have a reasonable expectation for revenue in the future. We have capped our subsidies at very modest numbers, and our chief financial officer has vetted these numbers and studied them, and we believe that the first 5 years of anticipated costs to this authority in the original contract relative to the settlement that's on the table today, that our cash out will be less than half of what it otherwise would have been. And our exposure to losses has been eliminated completely. In the area of, let's call it the non-monetary issues, the access to the outdoor spaces that Asphalt Green will have to run its summer camps, which is an essential component of its program, has been negotiated, understood, will be documented in the final contract. So we're not in a situation where they have the fields and others have to figure out whether they can fit in. We're in a situation where Asphalt Green's access to those fields is known amount of time, it's a specific schedule, and the rest of the time and the rest of the space remains under the control of the authority. There are a number of groups in the community that have had access to those fields. They've been very concerned about maintaining that access. We are sensitive to those concerns, and as a result, the authority undertook a slight change in policy and will be issuing 3-year permits for those users rather than 1 year at a time, to provide a sense of continuity to those groups that they're going to be able to function as we go into the future. Access to the community center itself for non-Asphalt Green related activities will be available on a permit basis in the ordinary course. Those applications will come to the authority. The authority will deal with Asphalt Green. I believe, first of all, the contract will state that these will be dealt with in good faith and handled in an expeditious way. I think that based on all of the conversations I've had in great deal of detail around this issue with the management of Asphalt Green, they're going to honor that commitment. And if they don't, we have our remedies. The auditorium that's built into this center is an important component. There are community groups that would like to have access to that auditorium from time to time. There are prescribed hours embedded in our agreement that we control that auditorium for those periods and can issue permits for its use. It's as good as we are able to do with what we confront. And I believe that at the end of the day, having a qualified, experienced operator of that center to deliver this service to the community and to get it open in weeks, not months, in weeks, is absolutely essential. And so I am recommending today to the board approval of an amendment to the contract with Asphalt Green that will essentially implement the terms, the changes to the contract that I outlined here today verbally. Open for comment, discussion, questions, etc.
Do you want to just expound on the transparency issue that drove a lot of the renegotiation?
Yeah.
That was an issue for the board.
Yes, it was, and rightly so. Under the existing contract, they spend the money, at the end of the year or at the end of the whatever periods, we would have the opportunity to understand how and why they spent the money with no control in advance over what they were doing. And if they were expending dollars in a way that might be deemed inappropriate use of taxpayer dollars, it would be an after-the-fact problem, and it would be our problem. By virtue of this amendment, we have eliminated that issue because we do not involve ourselves at all in their expenditures. And by the way, one comment I want to make. They have a fee schedule for the services they provide. The contract will now stipulate that there will be an advantage to residents of Battery Park City in respect of those costs. Because Battery Park City residents are paying either rent or they're paying their common charges if they're owners. You know, I'm talking about residents down here. And that money comes back through and funds this authority. And this authority is in fact providing a subsidy to Asphalt Green in respect of maintenance capex for the first 3 years and utilities on an ongoing basis, as I suggested. Now, we believe in the out years, the revenue will offset that and we'll end up with a few extra bucks. But at the end of the day, if I'm a resident here, some portion of my money is going toward this. So if I go there and I want to be a member, I ought to get a break relative to somebody that's not a resident of Battery Park City. Seems fair to me. So we have embedded that in a relationship, but in the arrangement. But from the standpoint of transparency, the way we dealt with that is that we just made it none of our business. It's not our money. So if they want to buy a steak dinner for somebody, they can buy a steak dinner. We don't have to read about it. I won't say the New York Post, since we have a New York Times reporter in the room. I'll say we don't have to read about it in the New York Times. Other questions? Yeah.
So you've outlined a set of terms that you've reached agreement with. We've reached agreement with Asphalt Green that is going to then be drafted into an amendment to the contract.
Yes.
So the action we're looking to do today is to approve those terms and allow council to draft the amendment that will come back to us.
That is correct. The resolution looks to empower the staff to negotiate and conclude that amendment to the contract, provided that the amendment, when it is completed and fully understood, complies in all material respects with the settlement that I have outlined. If there is any deviation, they have to come back to the board. Now, as a practical matter, I will circulate those drafts to the members so that you can see what's going on a real-time basis. And if you have concerns or there's something that needs clarification, we will talk about that informally on a one-on-one basis so there are no surprises.
Yeah. And this was previously a fully executed, in effect, contract.
Yes, it is.
I want to commend our staff for elevating this and bringing this to our attention over the last couple of months. And I want to commend you for coming up with this solution, given what we had to work with. I think both parties have done stellar job for the authority.
Thank you, John. And I just want to say publicly, I found the Asphalt Green chairman and senior management of that group to be excellent people to work with. They had a contract. They had every right to enforce it. I said, you know what? I just can't do it. We need to make significant changes here. They spent a day or two to think it over. They came back and said, let's make a deal that's fair. They've been excellent to work with. And I have very high hopes for their operation of this facility, and I just have to publicly commend Asphalt Green for coming to the table and finding a solution that meets our needs, gets the center open, and offers the community an opportunity to enjoy what we have spent tens of millions of dollars to create. Let's get it open, let's get going. Other questions or comments?
I was, like I guess all of the board members, very concerned about the way this contract, what it read, what it was really going to represent the authority as being extremely generous. So I once again, thank you for looking at the detail and making sure that taxpayer money is spent appropriately. I think you did a great job with that. I just want to know, right, today, we're just approving that there will be an amendment drafted. Once that amendment is drafted, then we come back together and we approve what's in the amendment, or...
All right, Fernando, if we want to do that, we're going to have to call a special meeting, because what we're trying to do is open this center by December 1st.
I understand that,
Our next
but
meeting is not until November what?
but the amendment is not
I
prepared yet,
understand.
am I correct?
That's correct.
Okay.
What this resolution says is that we empower staff, which is...
I understand. In other words, we don't have to reconvene again in order to sign the amendment.
That's what we're saying.
Okay.
Now, you don't have to approve that, but the request is that if if staff certifies that the amendment to the contract meets in all material respects the outline of the settlement that has been provided to the members, that they are empowered to execute it and implement it.
What I'd like to add to that, if possible, is, I mean, we can turn this over in a day. If we could see that amendment, you know, just before staff, you know, puts the seal of approval on it, and you give us 24 hours to come back, and if we don't come back, then they're empowered. I think that I would feel better that way. I'd like to review it.
Okay.
I think we've been through a lot with this whole, you know, controversy of this contract, and I know that what you're doing is the right thing. But I would just like to at least have 24 hours to review it and just text you back. It's approved. I don't know if the other board members want to do that, but I'd like to do that. And secondly, they're prepared to sign this amendment almost immediately, am I correct?
Yes.
Okay, and they will be open by December 1st.
That's their objective, depending on how quick we can turn the paperwork.
Okay.
I'm not going to let them near the center until we have a signed agreement.
I think that we're a small enough ship that we can turn this around rather quickly. I just asked for at least a few hours to review it. I don't think that's...
Okay, let me make a suggestion. One, it was our intent to deliver the amendment to all members when we get it, so you can read it and understand it and have it for more than 24 hours. If you would like, we can schedule a public meeting by telephone to formally ratify the amendment. Can we do that or not? We can't?
Special meeting, but not by phone.
Oh, people have to come in person.
I don't want to complicate things. I just basically would like, in the amendment, to basically say that we do empower staff, but we would like at least 24 hours to just take a look at the document.
Why don't we just
To review.
modify what Dennis suggested, which is give us the document, give us 48 hours, whatever is comfortable.
24 is good.
And then let's schedule a conference call, so any questions of clarification we might have, we have an opportunity to ask.
For informational
For
purposes.
information
That's correct.
purposes.
Can we do that, folks?
We said a public. When are you gonna say, are you trying to do a public meeting?
No, the suggestion now is that after the members have an opportunity to read the amendment,
And they call
that we
you
have a
with
telephone
questions?
call to ventilate any issues or any informational stuff that they want to go through.
Yes.
Is that
As
not
it is,
subject
that
to
if
public
you have a
notice?
Quorum,
Yeah,
that
it's
is
a
a public meeting and it requires notice and it has to be open to the public. So that's the problem.
So wouldn't
So how do we get
wouldn't each
around
board
that?
member
Really,
be able
each
to
board
review
member can
and
review and
respond
file.
if they feel the
Okay,
need
all right,
to
all right,
respond?
all right, so here's what we're gonna do. We're gonna deliver the amendment to the members. I'm gonna personally canvass each member one at a time to determine whether they have any questions or comments. If when I have all of that feedback, there is a compelling reason why this board should reconvene, we will call a public meeting and we will reconvene.
That works.
Does that work for you?
That's excellent. That's exactly what
All
I
right.
was asking for.
Other discussion? Can I call the question? We have a motion.
So
Moved by Mr. Mateo.
Can I read the resolution?
Oh, I'm sorry, you have to read it. Go ahead and read it. I like to vote blind.
Carl, where are you?
This is an authorization to amend the contract with Asphalt Green. Be it resolved that in accordance with materials presented to this meeting, which all the members received, General Counsel of the BatteryPark City Authority or to designate any of them hereby is authorized to execute an amendment to the contract with Asphalt Green to reflect the revised terms and conditions presented in such materials.
That brings up a point. Have we delivered those final materials to the members? don't think we have. Talked about it. They had exhibits in our executive session a month ago. We collected those exhibits back for reasons of confidentiality. Each member, when they leave here today, will have the specific document that we will execute, which is a non-binding term sheet, which embodies the terms and conditions I have described verbally, and they will have the chief financial officer's analysis of prospective cost and the analysis of prospective cost under the amended contract if it gets executed. Those three pieces of paper will be in your possession. Council is referring to materials you have received. You will have the materials. Go ahead, fellows. Keep reading.
Okay, so I'm done with it. Resolved that the general counsel of the authority is authorized and empowered to execute and deliver the amended contract on behalf of the authority, subject to such changes as the officer or officers executing the amended contract shall, with the advice of counsel, approve as necessary and appropriate and in the best interest of the authority. Resolved finally that the general counsel shall be authorized and empowered to execute all such other and further documents and take all further actions as may be necessary, desirable, appropriate in connection with the transactions contemplated in the resolution. On any such execution of the documents or other further actions heretofore taken or hereby ratified, and any actions hereafter taken are confirmed and approved. So once we get the, modify the contract to reflect the new terms and conditions, we will then circulate that document. Is that the way I
That's correct.
understand this? So prior to execution, we'll wait for your ultimate sign-off that all the members are satisfied.
We will conduct an individual informational session with each member after they have had the opportunity to review the actual amendment to the contract. And that must occur, that shall occur prior to execution of the final amended contract.
And I will add that language
Right.
to the amendment. And so as revised, I will incorporate that into the resolution, and it will become a part of the record.
Okay. So that's the resolution we're voting on. Do we have a motion?
So moved.
From Mr. Mateo, do we have a second?
Second.
We have multiple seconds. Everybody's already voted? Carried. Okay.
Thank you, Dennis, for this.
Oh.
Thank you to the members of the board. We've worked well together.
No, it's been interesting. All right, so now we need Witham Smith